Center. And I would like you all to welcome God's Favor, Angela, Toluwalashe, Erogene, Ife, and Bukola. It's nice having you all on the call this evening, and thank you for taking your time to be with us this evening. And without wasting much of your time, we intend to conclude the session in about an hour and probably an hour and 20 minutes maximum. And the session would go this way. I would, of course, introduce what we will be talking about this evening. And I will go on to ask a series of questions to our bright interns here. And by the end of that, if there are other questions from our guests, we would be taking that before we would hand off for the day. Notably, our discussions today is going to be centered on the Icj'S advisory opinion, which was delivered on the 23rd of July 2025, which was just last year. And in that particular decision, the Icj's, of course, delivered a very historic opinion on the obligation of states regarding climate change. And for us in the global south, this is not just a opinion, this is a matter of survival. And so today, of course, I'm very proud to present the research interns here, who are the authors of a very wonderful and well-researched piece, which forms the basis of our discussions. And we would divide today's discussions into 4 parts. The first part will be dealing with the legal framework. And the second part will be talking about the nature of the obligations. The third part will be human rights and corporate liabilities. And the fourth part will be existential threats and future justice. I would want to give our interns, who of course are the panel members, just a minute each to introduce yourself. And we'll start with God's Favor. Just say hi to the guest here and everyone.
All right. Just can you confirm that you can hear me?
Very clearly.
All right. So good evening, everyone. My name is God's Favor and I am an intern at the Lata Center for International Law and Comparative Constitutionalism in Africa. And I'm glad to be here, and I look forward to having a robust discussion on this Icj's advisory opinion.
Thank you, God's Favor. Would we get Erogene, please?
Hi, please confirm if you can hear me.
Clearly.
Okay. Good evening, everyone. My name is Erogene, and I'm an international law intern here at the Lata Center of International Law and Comparative Constitutionalism in Africa. And I look forward to an evening of insightful discussions around the Icj's climate change advisory opinion. Thank you.
Thank you. It's a pleasure having you here. Toluwalashe, can we have you, please?
Okay, good evening. Please, can you hear me?
Yes, very well.
Okay, good evening, everyone. My name is Alukolo Kuntuluwalashe, and I'm an international law intern here at the Lata Center for International Law and Comparative Constitutionalism in Africa. And I look forward to having a very nice and insightful discussion centered around the Icj's advisory opinion on climate change. Thank you.
Thank you so much. Do we have Angela on the call? I don't think so. Do we have Ife? Do you want to turn on your camera and introduce yourself, please?
Yeah. Good evening, everyone. My name is Ifeoluwa Deborah Akinshola, and I am an intern at the Lata Center for International Law and Comparative Constitutionalism in Africa, and I look forward to having an insightful discussion with us concerning the Icj's advisory opinion on climate change. Thank you.
Thank you, Ife. For that, do we have Bukola on the call, please? Very well then, that is well noted. So this will be our panel members for this session. And right into our discussions. Our first question would go to Tolu Alashe. And we just spoke about how this advisory opinion is a landmark one and particularly very important for us in the global south because of we are always almost at the end, the receiving part of all these climate activities. I just noticed that Angela joined us. Angela, do you want to introduce yourself, please, so we could continue? Angela, can you hear us? You are muted. Just unmute yourself. That's so while Angela sorts out her technical issues, I would go on with Tolu Alashe. And in your report, right, you noted that the opinion calls for a loophole closer, right? And then the opinion also stated that customary international law applies universally. Now, practically speaking, if a major emitter like the US or China were to withdraw from the Paris Agreement tomorrow, would this opinion prevent them from escaping their legal obligations or to reduce emissions?
Okay, thank you for the question. Please, can you hear me?
Very well.
Okay, so yes, regarding the question, I believe that if a major emitter like the US or the USA or China decides to like withdraw from the Paris Agreement, it does not excuse them from their legal obligations. The first reason I will give is under customary international law. Under customary international law, we have two principles that are at play here. That's like the principle of due diligence and the no harm rule. So every international state has the duty to ensure that the activities within their jurisdiction does not cause transboundary harm to the climate. They have a duty to ensure that everything they are doing within the jurisdiction of their state is for the benefit of climate, so that it does not affect the climate in a wrong way. And secondly, I would mention international law, international human rights law general. Now, in the advisory opinion, the Icj's stated that every individual is entitled to the enjoyment of a clean, healthy, and good environment, which is a prerequisite for enjoyment of other human rights, such as the right to life, right to good health, and all. So, as a member of the international society, major emitters, all states are bound by customary international law and international human rights law. So, withdrawing from the Paris Agreement, yes, it reduces the cooperation between international states, but it does not excuse them from their legal obligations under customary international law and international human rights law. Also, the Icj's stated in their advisory opinion that climate change is a global harm, that it is a concern for everybody in the world. Major emitters especially have higher responsibilities to ensure that everything they do within their state does not cause major harm to the climate of the world. So that's my submission on that question.
Thank you so much, Tolu Alashe. So what we establish now, or what you establish, is that the law applies to everyone. So now we're going to be looking at the standard of that law, and the courts use very specific language regarding what is expected of the states. And Angela, have you been able to sort out your technical issue, please? I do not think so. So yeah, we were just talking about how the court, of course, use very specific language regarding what is expected of states. And then we would want to, of course, get Erogene on this question in that regard. And Erogene, the opinion stated that developed countries have a duty to take the lead, of course, which Tolu Alashe just mentioned just now. So the question is this purely symbolic, or does it place a higher legal burden of proof on developed nations to demonstrate that their climate policies are sufficient?
All right, thank you so much for this question. So regarding the developed countries taking the lead, is not merely symbolic. So in the final judgment of the ICJ, in the final operative clause rather, the ICJ stated that the developed countries, these are the countries under Annex 1 in the Paris Agreement. So we have developed countries such as Belgium, you have the United States, you have Canada. So these developed countries, because of the fact that they are producing more, they emit more, they have a higher threshold of responsibility. So because of this, there's a higher standard of conduct, which places a higher burden of proof on these developed countries to make sure that they are complying with the climate change policies. For example, in the Paris Agreement, the temperature increase of 1.5 degrees Celsius was mentioned. And for instance, there's the principle of the common but differentiated responsibility. And what this principle basically puts is that although the universal standard is that 1.5 degrees Celsius, developed countries do have a higher standard of proof. They have a higher standard of conduct, rather, when it comes to creating NDCs that make sure that they are in track to meet this 1.5 degrees Celsius. Thank you.
Thank you so much, Egogen. I think that was definitely insightful. So what I get here is that taking the lead doesn't imply a rigorous standard, actually. Do we have Bukola on this call? I don't think we have Bukola here. Angela, are you able to speak, please?
Yes, yes, yes. I'm so sorry for the disruption that
Oh,
been
no
having
worries. I have
necessity.
to apologize. We understand that. So can we just go back a little bit, because Angela, you are actually a very important part of this research, and we want to, of course, get your opinion on some of these things. So going back to the foundation, right? For years, major powers have argued that climate change should only be handled under treaties like the Paris Agreement, which of course are often non-punitive. I think that's one of the reasons they've advanced such arguments in any case, since they are mostly the major polluters and emitters of these pollutants. So the question now is, a major, of course, the major argument is that it should be, the Paris Agreement is lex specialis and should be the one which, of course, applies, which means it should be the only law applying, excluding customary international law. And the courts, of course, unanimously, this was very unanimous and very clear and emphatic at the same time in rejecting these arguments. And can you explain why preserving the applicability of general international law is victory for climate justice?
Yes, sure, I can. Thank you very much for the question. So this question basically boils down to why exactly the lex specialist argument was rejected. This argument was presented by high emitting states like the United States, the United Kingdom, Russia, and a couple of other states. They were basically agitating that climate change treaties like the Kyoto Protocol, the Paris Agreement, the UNFCCC should be the special law guiding climate international law. But the ICJ rejected this argument for certain reasons, but for three major reasons. First of all, they looked at the nature of these treaties. Now, these treaties were mostly procedural, just stating the procedures on how states would cooperate to ensure climate justice, but they left out the international law principles that form the basis of state obligations, like the due diligence principle, the transboundary harm principle. And so the ICJ, sorry, viewed this as a constraint or a reason why they would not be able to use this as a lex specialist, because it would give states the opportunity to evade responsibility. So viewing that from that angle, the nature of these treaties, that was one of the reasons why it was rejected. Also, the I think it was Article 31.3c of the Vienna Convention on the Law of Treaties emphasizes systemic integration in international law, which basically is a principle that states that laws should be harmonized and integrated in interpretation and in ensuring in ensuring justice in general. So going by this principle, the ICJ viewed it necessary that all these laws be joined together to ensure that there is a proper interpretation and also a form of justice, rather than leaving out certain principles which are even the foundational principles of climate justice. And the final reason was also that there was no clear intent to um, derogate from general international law. So basically, for a law to be lex specialist, there has to be a special intent to states have to must defend or clarify a specific intent on why they should derogate from general international law principles. But going back to the format of these laws, the design of these laws, they are not designed in a way that seeks to derogate from these laws. Rather, they are designed in a way that wants to integrate general international law and customary law principles. For example, the United Framework Convention on Climate Change, that's the UNFCCC, and the Paris Agreement, in their preamble, both contain references to the United Nations Charter and affirm the obligations of states, under customary international law. So from this, you can see that there's a need for these laws to be integrated and not one left out. Is it Does it help climate justice? Yes, it really does. In fact, preserving these general international law rules help climate justice because it affirms these obligations and it makes the climate change treaties more of tools for cooperation among states than shields against responsibility, like what states would want to use them to do. So viewing this and viewing the I would also say like history of the states that presented these arguments, the ICJ would have viewed that there was an intent to probably um, utilize these laws in a way that would help them evade accountability and to further cement the state obligations, which was even the whole essence of the advisory opinion in the beginning. The court rejected these arguments.
That was definitely brilliant and very insightful. I don't think I actually want to even comment on that. Thank you so much for that opinion there. And I
Thank
think what I could throw, of course, yeah, is of course, with subsequent opinions expressed within that advisory opinion, we noted that the court described the standard of due diligence required of states as stringent, right? And in this regard, Ife, I would want to come back to you. Right? Due diligence, of course, must be measured against facts, isn't it? And this now brings us to science. Now, what we would also note in that advisory opinion is that the court relied heavily on the IPCC report as authoritative scientific evidence. Does this effectively turn scientific consensus into legal facts? And how does this impact states that try to rely on their own, less alarming national scientific data?
Right. Thank you for that question. Once again, good evening, everybody. Can everybody confirm that they can hear me, please?
Very well, we can.
Okay, thank you very much. So I think the first thing that I would like to mention is that what is the IPCC, right? So the IPCC is the Intergovernmental Panel on Climate Change. So this body is like the leading United Nations body that does research into science on climate change and provides scientific reports on anything related to climate change for the United Nations, right? So one thing we should note is that the IPCC is considered by the United Nations to be an authoritative body when it comes to anything related to climate change, climate activities done by the international community. And these scientific conclusions, because when these scientists go to make this research, they come to conclusions, right? So these conclusions can now come and serve as factual factual reasons for the ICJ to move forward with legal analysis on any topic related to climate change. So far, the ICJ, the United Nations, see the IPCC as a leading authoritative body. Then legal consequences can come. Legal consequences can be meted out to states based on the findings of the IPCC on climate change activities by the international community. And one thing that we should also note is that as far as the ICJ, the United Nations has recognized the IPCC as this leading body on science, climate change, then no state in the international community can claim ignorance or can feign ignorance when it comes to matters related to climate change. Because just as Angela has duly mentioned, climate change or climate activities is of an ergo omnes character. That is, it is a duty that is owed by the whole international community to each other. One state cannot say that because they are not contributing to it, then they are not a part of the concept of climate change. So basically, all I'm just trying to say is that yes, the ICJ can consider the reports of the IPCC, their authoritative reports, as factual evidence to move on with legal proceedings. Now to the second part of the question, whether or not states can rely on their own less less rigorous facts to counter what the IPCC brings to the ICJ. Now, the court relies on a principle called fair hearing. So every party to a suit, every party to an argument can bring forward their parts of the argument to support their cases. But anything that any individual state brings has to match up the intensity of what the IPCC brings before the ICJ. So they are allowed to bring it, of course, present their arguments, present their facts and cases before the ICJ. But then again, if it is to be considered by the ICJ, then it has to be that the state has noticed that there is some mistakes or discrepancies in the documents or the research that the IPCC has brought to be able to counter what the IPCC is presenting before the ICJ. So if there is nothing like that, if there is no new development in science, if there is no new discovery to what the IPCC has presented before the ICJ, then nothing being brought by individual members of the international community, that is the states, everything will be treated with less validity, exactly, less validity before the ICJ. Thank you.
Thank you so much. I think that's definitely some interesting perspective there, and which actually is also, should I say, problematic, because we look at the fact that if there is some discovery, some new discovery in science, then it's most likely the court will be persuaded against that. And a major feature of science is that it's constantly evolving. We are constantly developing new things. We are understanding deeper at granular level, things that previously were just understood at surface level. How do you think, I mean, just pushing back on this a little bit, how do you think how easy would it be to prove before the court that, the IPCC might have presented this report, but our own scientists believe otherwise, and they've conducted social experiments, and they are able to prove to some level of acceptance that this is, there might be some nuances to this. What do you think all of this could turn into?
Okay, thank you for the follow-up question. So just like I mentioned earlier, when it comes to legal proceedings or legal analysis before the court, in which case the ICJ is not exempted, there is a principle that allows each party to an argument, each party to a suit, to bring their documents and present their arguments before the court, right? So if a state is claiming that they have a scientific information or a scientific fact that contradicts what the IPCC has brought, then there could be a board, a mini board that goes through these facts, goes through this information before it is then presented to the court officially as scientific documents, right? So when this body now weighs what is in the IPCC's report and weighs what is in the individuals, because one thing about the international community as a whole is that when parties are being called before the court, they can choose to appear and they can choose to not appear. And this is very different to what we have in states, in local communities, right? So if within this time frame that a state has probably decided not to appear before the court, has found something very interesting, something that is highly contradicting to what the IPCC has brought, then if this board now considers that, okay, this information seems to be a very tangible information to this legal analysis, then they can now bring it before the ICJ. So of course, just like I said earlier, if the report, the scientific information, the scientific conclusion of such states, if it is not as cogent as what the IPCC has brought, then it cannot be treated with the same level of importance or the same level of validity as what the IPCC has brought. So it's just weighing it and seeing what exactly, if there are no major differences, then there is no need to present it before the court. If there's no new information, no new scientific discovery that is found in such reports, then there will be no need to present it before the court in the first instance. And I also believe that for a state to claim that they have something contradictory to what the IPCC has brought, then it actually has to be contradictory. Because a state would not want to waste their time in that sense, bringing unnecessary or unimportant information before the courts, right? So if I believe that even before a state can say that, oh, their report is contradictory to what the IPCC has brought, then in the true sense of it, it has to be contradictory. Thank you.
Thank you so much. That was definitely very insightful. And that was just to pick your opinion, just to get your opinion on that. That was really nice. Thank you so much for that beautiful response. Now let's just move or shift the focus now to the victims, right? The people. The court made significant links between the environment and human rights. And this question, well, I would want to get your opinion to Lualashe on this. And the point is the nexus, right? The court confirmed that climate change threatens the enjoyment of human rights. So, crucially, right, importantly, does this opinion treat the right to a clean, healthy, and sustainable environment as a standalone customary right, or is it still dependent on other rights like the right to life?
Okay, thank you very much for that question. So, the ICJ stated in its advisory opinion that every individual and states at large have the right to the enjoyment of clean, healthy, and sustainable environment. However, the court stated that this is a prerequisite to the enjoyment of other international human rights, like the right to life, right to health, right to food, and some other rights. So in its ICJ, in its advisory opinion, the ICJ did in fact state that okay, every individual and every state has the right to the enjoyment of the right to a clean and sustainable environment. However, this is a precondition to the right to the enjoyment of right to life. So if there is climate degradation, right, states would not have of individuals and states at large. So my submission on the question is that yes, the ICJ did mention that every individual has right to clean and sustainable environment. However, it is just a prerequisite to the enjoyment of other major rights like the right to life. So it did not treat it as a separate human right, but it treated it as it stated that it is an interconnection, like an interdependence on the right to life. Thank you.
Sure, I was just saying that that's actually interesting. And if you actually were going to ask me my view, I would have appreciated if the court were to treat that, of course, as standalone rights, so that we just get some higher level of protection for these rights. Particularly, in any case, we have several other instruments upon which this right could be founded, even at the international level. But importantly, in all of this, human rights violations often happen across borders, national borders. So emissions in Europe, in North America, in Asia, particularly in China, could cause droughts in Africa. So, Erogene, can we get you on this? We know that one of the biggest hurdles in human rights law is jurisdiction. Did the court clarify whether a state, for instance, in Europe, a European state, which violates human rights of people in Africa, for instance, in Nigeria, through its emission? So is it possible for a state in Europe to violate the human rights of states in Africa? And in this regard, does human rights jurisdiction extend beyond boundaries in the context of climate change? That question is for you, Erogene. If you can hear us, please.
Okay, please confirm if you can hear me.
Yes, please go ahead.
Can you hear me?
Yes, go ahead. We can
Yes,
hear you
you
clearly.
can.
Okay, so the concept of human rights and jurisdictionality in terms of climate change and enforcement of it in relation to climate change. So one thing the ICJ opinion really emphasized was the erga omnes character of climate change. So what this means is that climate change is a concern for the entire international community. It's not just some particular states or just a particular group of states. And emissions and climate change and things that arise from climate change also affect other countries. So no country can simply claim that its emissions or its activities are simply affecting its country or its own territory or its own jurisdiction. The very nature of climate change involves that it affects the entire international community and is transboundary, meaning that it's no respecter of boundaries or jurisdictions or country lines. Now, in light of this, because of this very nature of the transboundary nature of climate change and greenhouse gas emissions. Because of this, the enforcement of human rights in relation to climate change can be brought forth. So now the extraterritorial application in related cases of climate change and climate-related situations. The court, in its advisory opinion, did not exclude extraterritorial application, but also knows that it must be assessed in light of whatever treaty is concerned, and it must be assessed on a case-by-case basis. So it didn't provide, let me say, a blanket or a uniform decision as to the enforcement of human rights in terms of climate change. But what the court said that it will be, number one, the treaty concerned, and number two, it will be assessed on a case-by-case basis. Thank you.
Thank you again for that response. Well, I think what about the companies extracting oil? So these companies are not states, right? But they are major players. And in this regard, Ife, I would want to get your opinion. The opinion confirms that states must regulate private actors under their jurisdiction. Does this create a direct pathway for holding states responsible for the emissions of their multinational oil and gas companies operating here in Africa?
Okay, thank you very much. Please confirm that you can
Yeah,
hear
go
me.
ahead.
So one major thing we need to note is that the responsibility that ICJ metes out to states is the responsibility of due diligence. That is, they have to be very diligent in ensuring that their private actors within their jurisdiction adhere to climate restrictions, climate actions within the international community, right? So that is the major thing here. But it doesn't create a direct responsibility on states, except in situations where it appears to be the private actors in this sense appear to be directly under such state or are acting on behalf of that state. All they just have to make sure is that the private actors within their jurisdictions make sure that in every activity of exploration, production, anything that can be harmful to climate change, right? Climate activities, they have to make sure that they prevent any form of foreseeable harm to the climate activity for the international community, because every action of these private actors contributes to climate change. So while it doesn't create a direct responsibility, it serves as a legal basis for these countries to ensure that private actors within their jurisdiction have to comply with climate regulations, climate activities, and in all of their environmental conduct, they make sure that they are not contributing intentionally, exactly, intentionally to climate actions that are harmful to the climate of the international community. That's it. Thank you.
Thank you, Ife, for that. That is very nice. And of course, we are entering the final segment of this discussion. This will be the part four, where we'll be talking about existential threats and future justice. And God's favor now, can we get to you? Now, let's talk about resources. For decades, finance has been treated by some as charity or aid. Does this opinion crystallize the provision of climate finance and technology transfer to developing states as a binding legal obligation rather than a voluntary contribution.
All right. Can you hear me?
Very well.
All right. So, firstly, we need to understand that the ICJ advisory opinion is not a standalone decision. It basically provided interpretation to existing legal frameworks, particularly treaty laws, right? And basically, in its interpretation, it's made reference to, or it's basically interpreted the provision in this regard. It interpreted the provision of the UNFCCC, that is the United Nations Framework Convention on Climate Change, and the Paris Convention. And basically, these existing laws already made provisions for financial obligation of states, and in fact, bridging the technology gaps between states. So it's common knowledge, and you would acknowledge the fact that the powers, or let's say the capacities of states in this regard, I mean, in terms of finances and in terms of technology, they vary. We have some states that wield more power in that regard. The industrialized states like China, the United States, and all. And in the same vein, these states also contribute mostly to climate pollution or climate change in that regard. And so, this advisory opinion, while interpreting the provisions of the Paris Agreement and the UNFCCC, it provides that states with higher capacities in this regard, or with more wealth, take the lead in mitigating the effects of climate change. And in relation to your question, over time, states have taken, or the attitude of states towards this finances towards developing countries have, in some instances, been taken as charity. However, I think that this particular advisory opinion clarifies that this is a responsibility. It places it as a duty on their part. And so states that wield more financial capacities, and if, in terms of technology as well, they're expected or they're required to take the lead in advancing climate change. And so in subsequent times, and when such aids in that sense, or when such finances are channeled towards developing countries, particularly in the African region, I don't think it should be considered to be aid. It's more of a responsibility on their part to advance climate change. And this is also will I say it's a development for African and developing countries, basically, and to advocate more for these higher not higher states in this regard, but more financial capable states to take on this responsibility of contributing more towards advancing and mitigating the effects of climate change, which of course is caused mostly by them.
Well, that's definitely some very strong answers there. But you would, of course, note that for some nations, money is not enough. They are losing their land physically. We're talking about real territorial loss. So staying with you, God's favor, regarding the freezing of baselines for our small developing island states, of course, we are the main parties in this particular advisory opinion. So the shifting of maritime baseline due to sea level rise is a major economic threat. And the court suggested that baseline should remain fixed. What is the legal basis for this freezing of maritime zone, given that the United Nations Convention on the Law of the Seas usually relies on physical geography?
All right, yeah, rightly so. The courts emphasized the stability of.
Did you get my question, God's favor?
Yes, I
Or
did.
do you want me to take it again?
No, I did. Can you hear me?
Yes, I can hear you. Can you hear me?
Yes, I can.
All right. I was just trying to stay with you on this. And what I was just asking about is the issue of freezing up baseline, which the advisory opinion, or which was a major part of the advisory opinion. And we're talking about the small island developing states who were the major party at the ICJ in this particular matter. And I was asking about how the shifting of maritime baseline due to sea level rise is a major economic threat, and how the court suggested that such baseline should remain fixed. And I wanted you to just oppose this with the position under the United Nations Convention on the Law of the Seas, which rely on physical geography for the purpose of computing baseline and maritime boundaries.
All right. Thank you. So, yes, the court stated that maritime boundaries or baseline should be fixed, like you rightly mentioned. And like you stated as well, the people that pushed the most, the states that pushed the most rather for this advisory opinion were, small islands, states like so they were the ones that advocated the most for this part, right? In consideration of the United Nations Convention on Law of the Sea, like you rightly mentioned as well, it provides for fiscal territories in determining the status of states. However, and the court acknowledged the fact that the rising level of the sea or climate change generally, which in effect affects the sea level, it acknowledged the fact that while it is inevitable, it also affects the maritime coastlines, the maritime boundaries of states. The court did well to acknowledge that fact. However, in relation to the UNCLOS, as I'll call it, the United Nations Convention on Law of the Sea, that particular treaty provides for states to define, in that sense, to define their boundaries. So states are required to define their geographical boundaries, and such geographical what would I put it as now? Such geographic indications are supposed to be submitted to the Secretary of State of the United Nations, right? However, the UNCLOS as well provides for it does not provide for these boundaries or these geographical limits to be varied, right? So once states submit these, once they publish and submit or disclose these their boundaries, they are not the UNCLOS do not provide, do not make any provisions for them rather to vary these particular boundaries. So the court, while acknowledging the fact that the rising level of the sea and climate change in general affects the position or the geographical positions of these island states and low boundary or low lying rather states, it also stated that the for statehood, basically, in international law, statehood is not just determined by fiscal territory, right? There are a lot of other factors. And while this climate change or rise in sea level might affect the fiscal status of states, the court observed that that is not the only requirement for statehood, firstly. Secondly, the Vienna Convention on Interpretation of Treaties also provides for treaties to be interpreted in line with or in consideration of state practices, right? And the courts noted this as well, that based on state practices, states typically have come to acknowledge the fact that these boundaries should be fixed. We have regional and cross-regional organizations, such as the Organization for the OAP, the Organization of African States and Caribbean, all of those. They have acknowledged in several instances this particular provision that state boundaries should be fixed. And so the court, right, while giving this interpretation and in consideration of these state practices, both within Africa, the Caribbean states, the Pacific, and all around, they have acknowledged this fact that states boundaries should be fixed. And so the court, in consideration of that, also tilted towards the position or the perspective that these boundaries should be fixed. In addition, right, based on the relying on logic, right, it's just logical and more beneficial to the international community that state boundaries should be fixed. In this way, it prevents territorial conflict of territory, because if states are to continually vary it at every rise in sea level, which the court already acknowledged that is inevitable, if at every change in the sea level or at every erosion of state boundaries, states have to go and redefine or recalculate or remeasure their boundaries, there would be uncertainties, right, in boundaries, right? There would be conflict arising from all of this. So I think it's just rational and logical for the ICJ to have taken this line. So in summary, the ICJ told this line because of there were no legal obligations in the UNCLOS demanding or requiring states to regulate or to vary their geographic limits, also based on state practices and basically on principles of rationality and all.
Thank you so much for that. I think that was very expansive and explanatory, detailed enough. But you did mention something that geographical boundaries is not, or territory, sorry, the territory is not the only determinant of statehood. And that suggests that even if the whole territory disappears, there might be something. And I want to just toe that line and to ask Angela your opinion on this. We know that the Montevideo Convention requires, generally, of course, requires a defined territory for statehood. But the courts affirm that a presumption of continuity for states losing territory to the sea, which Gospel has also alluded to. So the question is just shedding more light on what Gospel probably would have said. Is this a new rule of international law, or does it mean, what does it mean for the for UN membership of a submerged nation?
Okay, thank you very much for the question. So the Montevideo Convention of 1933, like we all know, basically established the constituent elements of forming a state. And in this advisory opinion, the ICJ stated that submerging states would continue to have a presumed continuity of statehood, regardless of whether their territory disappears. Now, is this a new rule? I would say no, because in other scenarios, in other interpretations of the constituent elements of the Montevideo Convention, the ICJ and the United Nations have demonstrated that even when a constituent element of a state, an already established state, is missing, it doesn't remove the the state's identity. So, for example, in I think it was 1940, when the Baltic states were annexed, that's Latvia, Estonia, and Lithuania, when they were annexed by the Soviet Union from 1940 to 1990, an annexation already threatens the government and the sovereignty of a state. And now the United Nations still did not revoke the membership of these states. They remained recognized as Estonia, Latvia, and Lithuania as we do know them now. Even after they gained independence in 1991, there was still a presumed continuity of their statehood. Same thing for when Austria was annexed by the Nazi Germany. They didn't lose their statehood, it still existed. So the ICJ just reasoned in that line that if the government and sovereignty of a state could be threatened, but they could still be recognized, why then should a state lose its statehood when its territory disappears? So that is why the ICJ reasoned in that line. So it's not a new rule, it's just the ICJ reasoning in a different perspective of already established actions that have shown that presumed continuity of state is a known principle in international law. And so, also, this is an advisory opinion which can't exactly establish rules or laws, but the best it can do is be like a guideline, a directive that will influence the making of new rules and other different interpretations of the Montevideo Convention. Montevideo Convention basically states the elements of forming a state, but removing an already established state identity is where the confusion and the issue is. So this presumed continuity of states is just there to grant states that legal identity, that whether or not a constituent element is missing, this state has already been established, is already recognized, and so would not suddenly become irrelevant or unrecognized again just because of a loss of its constituent elements. Now, how does this affect the United Nations membership? Once there's a presumed continuity of states, there is also continuity of United Nations membership, because membership of the United Nations by states is basically on the existence of a legal identity of a state. So where this state still exists, its Nations membership would still be valid. It would still have all the rights as a state, even though now the state would be in exile with leaders representing them from different aspects. But the interests of this state would still be pushed in the United Nations. Just like the example I gave of the Baltic states, even after their annexation, they were still recognized in the United Nations, and we still know them as these countries till today. There was also reference to legal rights of a state, and also some principles that you'd apply in understanding the rationale of the ICJ, like the principle of state certainty and state predictability. So in this situation now, I would take us back to normal legal principles, say like law of torts, where you would have defenses in arguments and you defenses to some torts, and they'll say act of God, something that is out of control. So relating it to the principle of predictability, the climate issues of submerging states is already out of control. So it is out of anyone's control, especially even after these steps have been taken to ensure climate justice and climate or try to save these countries. But where this doesn't work, it's already out of control. So the cost flowing from that angle, from that predictability of loss of territory of states, still emphasizes that if we can recognize states who lost government and lost their sovereignty through annexations, why not recognize these who their situations are even out of control?
Thank you, Angela, for that. I think that is explaining. I'm going to push that back a little bit on that, but this is how it's going to go. I'm going to ask you a question, and while you'll be answering, if our guests have any question, you would prepare that, because immediately after Angela gives a response to that question, we will take questions from the audience, and after that, we will take just one rapid fire question for every member of the panel, and we would close the session for today. So, Angela, I think this is actually problematic. I could distinguish the issue of losing territory from losing sovereignty, or should I say, a standing government. We've had the issue of government in exile, which is, of course, a well-known phenomenon in the international law. We had Ethiopia during the Second World War, when Italy invaded Ethiopia. We've had the case of the Baltic states, you said. But what is notable here is this state, of course, still had a defined territory where they could go back to. And we're talking about situations where there is no geography, there is actually no land, there is nowhere they would go back to. And looking at the issue, the migration crisis we've seen across the world, particularly for the regions who receive more of the migrants, we're talking about North America and Europe. We see how, unfortunately, Africans who are crossing, daring the Mediterranean to cross into Europe, are being treated. Right, we haven't even been able to sort out
Sorry, I think
the rights
because I
of
can't
immigrants at the
even.
international level. Can you hear me? You are muted. Unmute yourself, and if you
I said the video paused at some point, so I kind of lost what she said in that moment.
okay,
When he
I
was
will just
somewhere
recap.
in African state something.
Yeah, I was just saying, if it's Africa, then we're talking about Africans migrating to Europe and to North America, right? To talking about the United States and Canada, and we see how migrants are being treated. I'm just saying, at the international level, under international laws, we have not been able to sort out the rights of immigrants to a satisfiable level. Like, and yet we are now talking about states who would not have territory, which automatically means almost the totality of their population might have to migrate to some other territory of a sovereign state. So how is what's the legal framework? What does the advice group, what does the court envisage in terms of providing protection for those who would eventually turn to migrants, or is there going to be some land that will be carved out to them as their sovereign territory, or what's that going to look like for the purpose of continuing with their sovereign identity at the international level?
Thank you very much. So I believe that the United Nations in the United Nations, forgive me please, in the United Nations Charter and different other laws emphasize rights of individuals. So before even looking at individuals as migrants, they would protect the rights of these individuals in themselves. Now, creating a different land for them is where the issue is, basically, because like you rightly stated, there have not been a lot of laws or a lot of interpretations or pronouncements that have addressed that. But I would say that the United Nations would look more on preserving the identity of the individuals. The essence of maintaining their membership is to still keep that identity flowing, the identity of the individuals as members of a particular state, and so they grant them their rights to continue voting and every other thing a United Nations member state does. So I think the United Nations will take more of an individual approach to the situation. But also, then again, if a situation like that occurs, it is nonetheless yet an opportunity for nations to gather and to deliberate on what to do in that particular situation. But flowing from a lot of actions from the United States and even laws of the United States, they emphasize more on like rights of individuals, and that's why like there are opportunities for individuals to seek redress or seek in cases of human rights abuses.
Yeah, I think that's actually some very interesting perspective to that question. We would want to take any question from the audience. If there are any questions, you can raise your hand and we will take your question. If there are none, I would go straight to a closing question for the panelists. I don't see any hand raised. So this question is going to go this way. Tolu Alashe, you would give us your opinion. Erogene, you would go next. God Favor would go next. Ifeoluwa would go last. And we would step African nation must take to ensure that this advisory opinion does not just remain on paper, but actually changes reality.
I'm sorry, like the video paused at
Exactly.
the moment when you the question. So can you please come again?
Okay, we said Tolu Alashe would go first, Erogene would go second, God's Favor would go third, and Ife would go last in that order. And the question is simple. In just one sentence, what is the single most critical step African nations must take to ensure that this advisory opinion does not just remain on paper, but actually changes reality?
Okay, in my opinion, I think the most important step is for everybody to be willing to come together to work towards creating a better climate environment for everybody. So I would say cooperation and the willingness to actually work to ensure that activities within their state promote climate in a positive way and does not affect the climate in a negative way. Thank you.
Thank you. That was a good one sentence there. Go again, please.
Okay, so the advisory opinion was basically an interpretation of existing treaty laws relating to climate change. So most African countries are already parties to the various climate change conventions like the Paris Agreement and other treaty laws. So one thing that African nations can do basically is to ensure that drawing from the treaties themselves, they are in compliance with the treaties and they use the advisory opinion somewhat as a lens to interpret and to ensure compliance with the treaties which they are already party to. Thank you.
All right.
Thank you.
Yeah. So I would say that for African countries to maximize this advisory opinion, it comes from a place of advocating, right? So for the most of it, African countries are at the receiving end in most of this climate change. They contribute less compared to some other states, right? So the best or one of the best things they can do is to advocate for the implementation of some of the interpretations that the Icj'S has given to existing frameworks, like Erogen already mentioned.
Thank you, God's Favor. Ife?
Okay, so I think that an action that African nations can take is that instead of contributing to activities that would harm the climate harm the climate of the international community. They can instead come up with initiatives that would help contribute to the health of the climate of the international community. So instead of exposure, oil exposure, exploration exposure, and all of that, environmentally healthy activities that can contribute to climate health, African nations can try to key into those initiatives to help the whole international community at large.
Oh, thank you so much, Ife. And I think with this, we'll definitely be on up this session. And I really enjoyed all the perspective and the opinion which you've all shared. And I want to believe that the audience also share the same sentiment in this regard. Now, you would have noted that this opinion, of course, fundamentally shifted the grounds beneath us. And it has moved us from charity to obligation, from negligence to stringent diligence. So I want to thank God's Favor, Angela, Toluwalashe, Erogene, and Ife for your rigorous analysis. And of course, I want to thank the Lex Lata Center for putting this all together, which is definitely, we hope to see more of these in the future. So thank you all for joining us this evening, and thank you for listening. And we wish you a pleasant night's rest. Thank you all.
Much and good night, everyone.